Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Betty Baker Marshall, and Betty has her own law practice. She's an attorney, and she's in Campbell, California, and she's had her own law practice since 1994. She's a certified specialist in estate planning, trust, and probate law by the California Board of Legal Specialization of the State Bar of California. She received her JD degree from Santa Clara University School of Law in 1991 and a bachelor's degree in public administration from the University of San Francisco in 1985. And before she was a lawyer, she had jobs for the Sacramento County Public Administrator Guardian's Office, and she was a program and contract manager for the Santa Clara County Mental Health for Santa Clara County Mental Health, and she worked for the Public Guardian's Office in Santa Clara County. I take it that's where you met your husband.
That's true.
Okay,
That's
sir. Betty's husband is Russ Marshall, and he's a professional fiduciary and used to work for the Public Guardian's Office as well. Betty is the co-author of Continuing Education of the Bar Practice Manual on Conservatorships and speaks extensively on elder law issues and other topics related to estate planning and caring for incapacitated persons. So, Betty, thank you for joining me today.
Thank you for inviting me.
Okay. So today, Betty and I are going to be talking about some issues related to caring for friends, family members, and so forth. And I'm going to caution everybody to seek legal advice. We want you to. This is supposed to be an introduction to a conversation you should be having with your lawyer. And so many baby boomers are finding themselves caring for senior parents and friends.
That's right.
And so the great generations, it's petering out. There's not so many of them left. And the next generation is sort of moving in and requiring care and so forth. Even some of us baby boomers, darn it. They need to, in some cases, have some health care needs taken care of. So Betty and I are going to be talking about, what's required when you're trying to deal with this type of a situation of being a caregiver. So let's see here. So we'll start off with talking about an advanced health care directives. What is an advanced health care directive? How does that fit into this whole thing that we're talking about?
Well, specifically, advanced healthcare directive is an instruction about what to do at the end of life, what treatment or non-treatment that you want to have. For example, cardiac resuscitation, being put on a ventilator, whether you want to receive food and hydration, medication for pain, morphine, even if it hastens death, that sort of thing. And in California, that's combined with the power of attorney to make healthcare decisions. And that's more broad, but it's all related to medical health care. So it's the instruction about whether you should have a surgery. Let's say maybe somebody is 92 years old, and should they have surgery for their cancer? Is that what they want? It's not what they want. So they put those wishes and desires into their document. And the agent is required to follow the instructions of the principal. So when that document is drafted, the person who's going to make the decisions for someone else is called the agent, and the person who's drafting the document is called the principal. So it's the principal's desires that dictate what the agent can determine. They can't make their own decisions about because that's what they think. They have to follow the wishes of the principal. And if the principal says, I don't want that, even though maybe they said they did previously, then the agent can't impose that on them. If they want to impose something on them on the principal and they've said no, the agent can go to court and get an order ordering that, but they can't do it without the permission of the principal.
Right. So part of what's going on, because I was actually set for some minor surgery not too long ago, which fortunately I didn't need. But
good.
what I noticed is though that the hospitals are, they're definitely asking about these things, and they want to have them on file.
They're actually required when you are admitted to the hospital to give you a form. Now, you're not required to fill it out, but they're required to offer that to you. And they do very much encourage that you do that. The only difficulty I see with that is sometimes somebody already has one.
Yeah.
So they fill out the form because they think they need to on admission. And sometimes that form is inconsistent with what they drafted with more thought. And there could be a revocation of the form that they already have. So sometimes I see that there's some difficulty in there. Although I don't want to discourage people from filling that out if they don't have one. But if they do have one, that's an opportunity to offer that up to the hospital for them to use.
So I guess what I would say is, if you're going to be going to the hospital for some sort of a procedure, it's a good idea to bring this thing along with you.
That's right.
So that you're prepared as part of the admission process. Otherwise, you'll have an inconvenience or a conflict, like you said, and you may have an unintended consequence there.
Well, one thing, Mike, if I could interject, is that there are some nuances in the Advanced Healthcare Directive. It's a little bit complicated. And some of the things that might be in there, for example, are whether it's what we call a springing power or an immediate power. And there are nuances in making decisions about what end-of-life care you want and which you don't want. And I encourage people to have conversations with their family members, specifically the person or persons who are named as agents, to let them know more detail about their philosophy, because you can't really predict exactly what's going to happen to you or exactly what treatments might be available. And those kinds of nuances, that chance to inform other people and have that detailed discussion and thought, don't always happen when you're going to be admitted to the hospital. So it's best to do it ahead of time, and you're right, make sure that you have it handy to bring with you.
Yeah. So these are difficult, it's a difficult subject for many people to talk about with their family, and but it is important.
Yes,
and so sometimes we have to sort of drag out these difficult conversations, and part of it is for your family really to know what your feelings are related to this. So to say, I don't want the heroics. I don't want them beating me up, to try to bring me back. And things are more, the appropriate actions are different at different stages of life. I think all of us can agree.
Right, that's right.
So if you're 99 years old, and maybe you're just ready, to go. So.
Yes, I recently had a discussion with a 92-year-old client who's been diagnosed with cancer, and he's had some treatments, and he's a little apprehensive about any future ones because he doesn't want to be miserable for weeks and find that it doesn't really give him any more longevity for 6 months.
Yeah.
He wants to enjoy what he might have left of his life.
Right. Well, let's move along, and this sort of fits in though with the first part, and that is, what is a durable power of attorney for healthcare, and how does that really fit in with all the stuff we've been talking about here?
Yes, well, the Advanced Healthcare Directive, as I said, is for end of life, and the durable power of attorney for healthcare, which is combined in California, it gives an agent the authority to make those decisions, to sign papers for you. For example, if you were going into the hospital and you didn't retain consciousness or capacity for some reason, either related to what you're going there for or otherwise, someone would need to sign for you, and that person then is designated by you in the same document if you're using that traditional statutory document. And but what it doesn't do is allow them to do anything against your wishes, whether they're expressed in the document or you've expressed them during the treatment. And it also doesn't give them any right to impose personal care on you or make a placement against your wishes. And so if a placement is at issue, then you want to be able to consent to that. And let's say you had a brain damage or dementia, then you would want someone to make that decision for you. But unless you've specifically provided for that decision in the document, they really can't place you in those kinds of facilities without a court order. So those are things to think about if you want someone to have all of that authority to make those decisions when you can't make them. A durable power of attorney lasts after your capacity has gone. So if it's not a durable power of attorney, then it would terminate when your capacity was gone. So you want to be sure if you're having it done that you want a durable power of attorney. And you can have those two documents separate.
So I think, just a couple of thoughts related to this. So you may have a preference, for example, for a certain child for doing this, but if that child isn't available, then there may be some practical issues as far as whether that's the best choice for the person to do this.
It is possible for someone to give consent to a large number of things, whether they're around or not, but that usually relates to some chronic condition that they're familiar with. But you're right, if you have an accident or a sudden illness and they really need to see you and hold your hand and figure out what to do, then it's much better if they're local. So if they can hop on a plane, let's say they're in Southern California, that might work okay.
They're in New York, we're in California, that's a real problem.
So I see people, maybe they have a nurse in the family, so they automatically choose the nurse, even though that person might be out of state. And I don't know that a nurse has any particular affinity for making these decisions any more than any other caring child, but I can understand why they would make that choice.
Well, they think that they have that medical familiarity, and I guess I can understand that too, but anyway, I mean, I've been in this place, as you know, and whoever is in that spot, it's a huge responsibility, and so it's not something to be taken lightly, for any party. But on the other hand, it is important, and this is an important role that we're talking about here for this person to step in and make these decisions. And I guess related to this too, though, is that you don't have to make it alone. So yes, you may have the final decision, but when I was in this spot, I was, as you and I actually worked on this particular situation. So it was my brother-in-law's mother, and she decided to put me in this position because her sons weren't getting along. But when I was making these final end-of-life decisions, I was talking to both of her sons to get input from them to make sure that we were together on this thing, and agreed that this is what was best for her. And fortunately, actually, I was able to get them to cooperate pretty well with me through this whole process.
That's really good. You raise a really important point, is even though the agent is the one with the authority, I was in a case recently where there were several daughters, and the one with the agency power was saying, well, it's my decision, so I don't need to discuss it. And so legal proceedings were brought to include the other children. And I think that's really important. It's a position of trust. It's very personal. It's very important. I always think it's the most important document that people deal with. And so they really should. I'd like to send someone home and tell them, go, this is your homework, to raise these issues with your children and with your other family members that might be involved. And the agent should be involving everyone. It's kudos to you for doing that.
Yeah.
Yeah.
Okay, so what other preparations can you make for your care when your health declines?
Well, beyond your written instructions, like I said, this involvement of other people in making the decisions, and also preliminary to that, maybe talking to your doctor, maybe going online and reading up on things, staying abreast of what new treatments there are. For example, if you were to be diagnosed with cancer, there's lots of new treatments for different kinds of cancers, and so that would be important for you to know. I think the thing I learned in my practice is that families feel a tremendous amount of guilt and grief when they have to make these decisions, and they are doing so without sufficient information. Even if you filled out a document, it's surprising how general the document is, and the specific things about what your values are, and what you believe, and what you're afraid of, and those kinds of things are really important to let them know. Because I've had clients grieving, even though the document said something, they always felt like, I should have done more, I should have done less.
Yeah, well, these are difficult situations to deal with in any case, because we're talking about, again, end-of-life decisions and things like this. In other words, are we going to pull the plug, or are we going to, continue with the feeding tube or not?
Right.
And so on. And so, again, it is a huge responsibility, okay? But, as we said, it's necessary, and those decisions sometimes just have to be made. And we had a person that we were dealing with in another situation. Are we prolonging life or are we prolonging death? So this is pretty heavy stuff for my little show here, but anyway.
Well, but all of us will arrive at that place.
And so, so are we really creating a situation where there's going to be more suffering,
Yes.
And so these are difficult, because you don't know. In some cases, people can recover and so on, but again, if they're in this sort of a decline type of a mode, it may be just, it's the hard thing to do, is to let go. But sometimes you just have to. Okay. So maybe you can talk a little bit about some of these advantages and disadvantages relating to healthcare for a durable power of attorney, conservatorship, and living trust.
Well, I think I've explained the durable power of attorney. One of the things about it is it doesn't have to involve court. If you have someone who has written a document like that, appointed you as an agent, as you experienced, then you conferred with other family members and made the decision with no involvement of the court. And that works as long as the person doesn't express a wish. For example, if you made a decision and the principal said, I don't want that, or they were combative and they wouldn't cooperate, then those documents, because they're all voluntary and they can be revoked at will, then in order to protect and take care of someone who is in that situation, you may need to file a document in court. And we call that conservatorships in California. It's essentially an adult guardianship. In some states they call it that. And as to the person, I'm not talking about finance now, but as to the person, you have the power to make medical decisions and placement decisions, and those have limitations. Again, if you get a conservatorship, and in this case, we're no longer calling that person the principal, we're calling that person a conservatee. And they don't want the medical intervention, then you need to get what we call exclusive authority to make medical decisions from the court. It's a special order. and then you can overcome the objections of the conservatee and forced treatment. For example, I've been in cases where there's some very treatable cancer, but left untreated, the person would be maimed or die. And so you want to overcome that and that objection that they might have, or delusion that they might have. And so you want to get that order. And that you can get an order for just the treatment for that particular illness, or you can get an order for exclusive powers to make medical decisions for all issues. And then for placement in a conservatorship, you can get another special power that allows you to put someone in a dementia facility or call a memory facility. And you cannot put a conservatee in that kind of a facility which is secured without a special court order. It involves the doctor and a lawyer and the court investigator, and then the judge makes that order. And that's to protect people from being locked up against their will when they didn't really need it.
But the person could still, basically, they can agree themselves. So the issue is
not under conservatorship.
Well, not
they
under
can't
conservatorship.
Give permission, right?
Yeah, but what I'm saying is, we sort of have stages that we go through.
Yes.
And so, in some cases, though, again, the person's condition just debilitates, and they're in a position where they may, like you said, they may be delusional, fearful, paranoid. And so they're not making appropriate decisions. So you have to be able to have a process where,
Yes.
that the appropriate decisions can be made.
Right. That's right.
Yeah.
Even a conservatee, the conservator, who's the agent equivalent in that situation, has to make their decisions based on the wishes of the conservatee, as long as it's not harmful or detrimental to their duty. So I think we had some discussion about living wills before, and those are kind of not used in California anymore, but it was sort of the equivalent of Advanced Healthcare Directive.
Yeah.
They're still used, and they do express wishes, and those things that are not necessarily part of the law now can be used to advise of the wishes of the principal.
Now, living trusts have become quite popular.
Yes.
Okay, revocable living trusts and so forth. So most people these days have heard that term. In many respects, it's like a will substitute, I think. But maybe you can talk about living trusts and how they relate to this area of healthcare and so forth.
Living trust is primarily a financial document, and it's I think a lot of people want them in order to avoid probate, and there are these days less so because of a large tax exemption, but they can be used for other tax reasons. And there's a lot of features about them that are really desirable. They seldom have a healthcare decision making involved in them, but sometimes they do. So when anyone is looking at all of the array of documents that someone might have produced, they should read that living trust very carefully, because I've found references to placement in healthcare in those, in the past. I don't know why they are used that way, but sometimes they are.
Yeah. So the estate plan these days is sort of a package where you've got these healthcare documents that are produced in addition to the trust and will. So
That's true. A typical packet might be a will and a living trust, Advanced Healthcare Directive, and other kinds of powers of attorney for financial and property management, nomination of a conservator, and a HIPAA release to allow someone to get medical records, those kinds of things.
Yeah.
Even a living will.
Yes. Yeah. Okay. We only have maybe about 2.5 minutes left.
Oh, okay.
2 minutes, okay. So maybe talk a little bit about this issue of in-home care versus other alternatives.
anyone can stay in their own home. I mean, you could set up a virtual nursing home or hospital in your own home with enough money. So I'm always in favor, if that's what someone wants and they have the funds to stay in their own home and get appropriate and safe care, the whole array that they need, then that's a really good option. For those who can't, there are assisted living facilities. Some of them are large ones with apartments in them. Mm-hmm. Some of them are private homes, mm-hmm. where you live with usually up to 6 other people, and you're taken care of by someone who's not usually a medical professional. So that would require a little bit higher level of ability to take care of your personal needs and eat and that sort of thing. And then there are nursing homes, and those can be funded by either long-term care insurance with private funds or by Medi-Cal. And Medi-Cal will, with some deductible based on your income, Medi-Cal will pay the full cost of that. And there are recoveries for the payment of Medi-Cal unless you do some planning. Married couples have the best options for the avoidance of recovery. Okay.
Well, Betty, I think we're just about out of time again.
We always have a lot to say to each other.
It's a big area, really, yes. Though. But it's so important. So anyway, I want to thank you so much for joining me today.
It's my pleasure.
And sharing some of your background. Folks, again, this is just the beginning of a conversation that you should be having with your attorney and family, and but it is an important one, and so we'll hope you'll give it the attention it deserves. We'll see you next time on Financial Insider Weekly.